Next case is People versus Kelly Warren. You may.
Good morning, Your Honors.
Good morning.
Sorry. Good morning. May it please this honorable court. Michael Naughton on behalf of the appellant Kelly Warren in this matter. And at the outset, I'd like to share my time and notify the court of that with the Attorney General of the State of Michigan, Dana Nessel. It's a privilege to be able to do so, as well as Solicitor General Fadwa Humud, who's at council table as well. So the division we're asking the court for is 6 minutes for my argument, 7 minutes for the Attorney General, and 2 minutes for rebuttal. Very good. Thank you.
You'll have to try and reserve your rebuttal time on your own, but I wish you the best of luck with that.
Thank you. I'm watching the clock right now. I'm going to be very brief because my time is brief, and I understand there's a 3-minute window, but I'm happy to waive that. I just want to get in a few points and then answer any questions the court may have. At its most basic, this is a case about an agreement. And what constitutes an agreement? This is basic 101 contract stuff, going back to Harry Hand and the Bear and Cow. It's basic. But here, we're talking about something that's far more grave, and that's the ceremonial function of a plea in a trial court. And it is just that. There is a ceremonial function. I know there are members of this bench that served in the trial court in Wayne County, Macomb County, and I'm a defense attorney. I feel that fear when a defendant is standing next to me and he has to answer to a judge specific things that they agree to at the time of a plea, what those rights are that they're waiving, what it is that implicates them, and what decisions they have to make. In this case, what Mr. Warren was told was, quote, each of the charges carries with it, absent the habitual, a 5-year maximum charge. Is that correct, folks? What he wasn't told was that there was the possibility of a consecutive sentence because these were 2 charges of driving under the influence. He was facing stacked sentences. That didn't come up at the plea. And then when sentencing came, he was sentenced, and again, he wasn't notified before sentence that he could withdraw his plea because the judge was contemplating doing consecutive sentencing. He was simply sentenced to 2 terms, 2 to 5 consecutive, which he's serving right now. This is a critical stage. In the ability for a defendant to have knowledge when they're standing in front of a judge, one of the most important decisions they make in their life that has broad implications not just to them, but to victims, the prosecution, and the court, they should have full knowledge. And within the panoply of things that defendants should know about, the true consequence of the plea and consecutive sentencing is something that should be a part of that. Secondly, this is not a Strickland case. There's a lot of discussion in the prosecution's brief about this being an issue where defense counsel should have notified him. And I will very candidly say, yes, he should have. I was not trial counsel, I was appellate counsel, and we immediately filed within the timeframes of the statute a motion to withdraw his plea. But he should have known. But that doesn't obviate the need for the court to let Mr. Warren know that this was something that was on the horizon, and that didn't happen. And lastly, I want to talk about archival. I have to applaud the prosecution. Digging up 40 years of a rule that was never amended was no small feat. But that doesn't change the fact that sentencing law and the criminal jurisprudence in our state has changed substantially since that time. This is the right time to make a decision on a case like this, and this is the right time to discuss these issues in terms of notice and what someone understands and knows.
Counsel, I have a question. How do we think about I see some tension between deciding if a direct consequence of a plea is something that's mandatory on the one hand, and that's how some courts seem to think about it, and whether it's something that someone other than the sentencing court imposes. They seem in tension, right? I mean, consecutive sentencing is something the sentencing court imposes, but in this case, it's not mandatory. So how do you resolve the tension between those 2 ways to think about this particular sanction?
Yeah, Justice McCormick, the way I have rationalized it is it's that scene within Brown, where it talks about the true nature or the true consequence of the sentence itself. There is a scholarly debate that frankly is unsettled with this state court as to what is a collateral consequence and what's a direct consequence. But what Brown talks about is the true consequence. And here there was a true consequence to this plea. The step that we think is necessary for due process requirements is for the trial court to notify Mr. Warren and any other defendant. I'd like to point something out, that this is sort of a special case. This hasn't come up very often. Maybe that's why since 1981 we haven't had occasion to really visit this. But nonetheless, it's important, just like notifications for fourth habituals are, and sentencing enhancements like that, and as well as tethering in the Cole case that we cited.
I think even Mr. Porter would concede the defendant should have this, is entitled to this information, as you've said. You've conceded that the lawyer should have told him this information. So why should we think that the judge also has the duty of notifying the defendant of this? What brings it across the line into the information that the judge has to provide, or else it's a due process violation? And as a follow-up, if it is a due process violation, what should we think of? Would we remand it back for a hearing with the lawyer to determine if the lawyer actually told him this or not? Or does the defendant just win because he can provide a transcript where the judge didn't tell him this?
That's a good question, Justice Viviano, and the way I would respond to that is the only remedy under Brown is it goes back to the trial court. What we're asking for is for his plea to be withdrawn. It's tough medicine. It's tough medicine.
What if the lawyer told him? But now you're saying he didn't. I mean, not that we don't trust you, but what if his trial counsel says, well, hang on a second. I always tell my clients that information. Everybody just wins if the judge hasn't given that information?
I don't think so, Your Honor. I think that really underscores the importance of the court putting it on the record. Whether the trial counsel, in Padilla as well, Padilla never really faces the issue of whether it's a constitutional violation to not notify of immigration consequences. And I've got 20 seconds, so I'll be very, very quick. Forgive me. But a lawyer should do that, absolutely. But in terms of due process, so should the court. One of the things that you see in the cases cited by the prosecution, Fonville, and even Blanton, it's an absolute mess when someone doesn't know what they're talking about when they're in front of a court and a decision's being made. And those cases illustrate the mess that happens. I'm going to concede my time to the Attorney General. Thank you.
Good morning, Your Honors. May it please the Court, Attorney General Dana Nessel, appearing as amicus curiae on behalf of the appellant and appearing in my parents' patriae capacity as Attorney General, because I believe that this is a matter of substantial interest to the people of our state. And I do so as an advocate for basic fairness and transparency in our system of criminal justice. So I came to this office having practiced criminal law for some 25 years or more, about half of that as prosecutor, half of that as defense counsel. And so when I saw this case come through my department, it occurred to me that in the thousands of pleas that I've seen administered in trial courts all around this state, I had actually never seen a trial judge fail to advise a defendant of the possibility of a consecutive sentence and then proceed to sentence that defendant to a consecutive sentence. So it had just never occurred to me before that the practice of providing this information was not already mandated by law. And as everyone here knows, nearly all criminal cases are resolved by plea. And I can think of no single variable of a sentence more important to a criminal defendant than how much time he will serve. It's more important than knowing if you're going to be on a sex offenders registry, or whether or not you're pleading to a felony or a misdemeanor, or whether or not that crime may be expungible at some period. Maybe later on those things will become significant, but at the very moment that an individual is deciding whether or not to enter that plea, all they really care about is, how much time am I going to do? So to have a trial judge in a court of law misstate the one part of a defendant's sentence that he cares about the very most really only serves to undermine and erode an individual's faith, confidence, and trust in the integrity of the criminal justice system as much as anything that I've ever seen. And I believe it also serves to significantly diminish any hope of that defendant's rehabilitation, since instead of focusing on his own bad behavior, which led to his incarceration, any defendant in Mr. Warren's shoes is really likely to spend more time stewing in his perceived betrayal by the system than embracing remorse and attempting to better himself. And so I would urge the court to amend MCR 6.302 to add the requirement that the defendant must be advised and understand the possibility that one or more sentences may be ordered to run consecutive to one another. And I don't mean to over-dramatize this, but I think that the contact that a person may have with the criminal justice system will likely be the most substantial contact that they ever have with their government. And the criminal justice system in many ways is really a microcosm of our democratic society as a whole. So those who feel wronged by it are bound to perceive that all our state institutions are corrupt and inherently untrustworthy. And I think it diminishes our state as a whole when we do that. So if we look to the purpose of consecutive sentencing, and we can look to the Smith case back from 1985, the purpose is to enhance punishment for those found guilty of more serious crimes or who repeatedly engage in criminal acts. And so I would submit to the court, as Brother Counsel has done, it's really indistinguishable from Brown and from sentencing a defendant as a habitual offender. Each is discretionary, each calls for what might happen, and neither is a certainty, but we still do it nonetheless. And when we talk about things like direct sentencing versus collateral sentencing, I would submit that really that's an intellectual exercise that is not something that's performed when you're in a trial court and by the criminal defendant. They don't understand the difference between a direct consequence of their plea versus a collateral consequence. All they want to know is how much time they are going to serve, and all they will hear is one thing from the trial court judge during the course of the plea, and then potentially something very different at sentencing in the event that they are not advised by the court. And so there really is no difference in this way than informing the defendant, I think, of their maximum sentence. And I will say the other thing about that's interesting to me is when you give an individual a maximum sentence, which of course we're required to under the court rule, we don't know that the individual is going to serve their max. More often than not, in the Department of Corrections, they don't. And I would use uttering publishing as an example. Even if you get MDOC time, it's very unlikely that you're going to serve, say, an entire 14 years. But we still tell defendants they may serve a maximum of 14 years.
What's your opponent has argued that it emphasized the fact that this court rule emphasizes the requirement to advise at the maximum possible prison sentence for the offense, and any mandatory minimum required under law. And so their argument is, I'm advising you, your maximum offense here is the 5 years. The fact that the judge, I could tack that on to another. What's your counter argument to that?
Well, I would say that when you're looking at due process considerations, and when you're looking at whether or not that plea is truly given voluntarily and knowingly and understanding truly what the nature of the sentence will be, a criminal defendant is not going to understand that. Almost any individual will not understand that it's the offense, and when you're pleading to two offenses at the same time, that's what it means. They'll understand when you say 5 years, they'll understand when you say 10 years, but that's something that we can sit and we can parse those words out all we want here in the Michigan Hall of Justice, but trust me, when we go down to the Frank Murphy Hall of Justice, most criminal defendants are just not going to understand that. So when you talk about whether a plea is knowing and understanding, I simply would submit to you that it's not when you have the court saying one thing to a person, even if his counsel has properly advised him of something very different, they're going to listen to what the court has to say. The court is the purveyor of law in that courtroom, and he or she sits above all other people in that court. it is the trial court judge that they will listen to, and they will hear, say in this example, 5 years and not 10 years, which we know to be the true sentence in this case. I don't have much time left. I'm going to cede it back to Mr. Naughton. Thank you very much.
Well, you asked us, you gave some great arguments as to why the rule should be, and then you asked us, you urged us to amend the rule. So is your argument for relief here based on due process only?
Well, it's not based on due process only. I would say that even if you were to evaluate it by whether this is direct or collateral, I would say that the sentence that you received, the actual term of years you received, is really a direct impact received from your plea. So I don't know that you have to reach due process, but certainly do I believe that what occurred here is a violation.
The court rule as written would give the relief you're requesting, but you urge us to clarify the rule even more.
I do, Your Honor.
Okay.
I would urge the court to do so.
Understand.
Thank you.
Can I ask you just one question?
Yeah.
Madam Attorney General, as an experienced criminal litigator, you're doubtlessly aware, and I'm not educating you on anything you're not well aware of, that from the perspective of many looking at the criminal justice system, there are already far too many pleas that are taken in that system, and concomitantly, there are too many discouraged from going to trial to defend their rights at trial. Are you at all concerned that the same confusion that you talked about a few minutes ago may, as a result of hearing maximum potential consecutive sentences described at the sentencing process, discourage even more defendants from going to trial, fearful that what may be a very remote likelihood of a consecutive sentence is nevertheless looming over them and may again discourage a great many additional people from going to trial? Is that a legitimate concern that this court ought to have?
I think the most important thing is that they have an accurate understanding of what they're pleading to. That's more important than anything else. And if you look at almost every circumstance where a person actually does go to trial, generally speaking, the court, even though it's not mandated, the court generally informs the person and will ask the prosecutor, what is the plea offer in this case, so that the person knows what they are risking by going to trial, even though in that case they're not waiving a right, they're actually exercising a constitutional right. I think what's paramount here is that at all times that criminal defendant be aware of the time that they are actually facing.
Counsel, do you think there's a, yeah, I know you keep trying to sit down, but you try and run every time there's a break. Do you think there's a difference between being silent as to the possibility of consecutive sentences and what arguably here is being incorrectly told what you're facing? So your very able lawyer's excellent brief
Good job, guys.
Focuses a lot on whether it's problematic for a trial court to be silent as to the possibility of consecutive sentences. But it feels to me like it's a little different when this isn't a court being silent. The court has said to the defendant, the maximum possible sentence you're facing is 5 years.
Yeah, honestly, they're making a misrepresentation then to the defendant, which I think is incredibly problematic. But it's so easy to cure this, obviously, by, this easy amendment to the court rule, in which case you would merely say, well, if you were to be sentenced concurrently, then these two sentences would run together. You'd be facing a maximum of 5 years. If you were to be sentenced consecutively, which I can also do, then you could be sentenced to a maximum of 10 years.
But fixing it going forward doesn't give this particular defendant relief unless you think the current version of the court rule already requires what you think we should make even more clear.
I think it should be clarified. I think more clarity is always better. I do think that Mr. Warren should be granted relief and that he should be permitted to set aside his plea and go to trial. And I will say that I think to Justice Markman's contention is too many people do waive their right to go to trial, and we shouldn't be so afraid of it that we feel like we have to say anything or do anything to force people into pleas. This set of circumstances doesn't happen very often. You very rarely see it. But I would submit that when you do see it, it is a miscarriage of justice, and that person should be able to withdraw their plea and exercise their right to have a trial by a jury of their peers.
Can I ask one last question? I sort of agree with most of your background experience that you've drawn on. Your own experience is similar to mine. In terms of fundamental fairness, I think the defendant's entitled to this information. I think as a trial judge, if I had a situation where the defendant seemed surprised by that outcome, I might even, or probably would have let the defendant withdraw his or her plea. But in terms of sort of the background norm of what a defendant who's standing before the court expects, why shouldn't I think that a defendant who's told the maximum offense for, or maximum sentence for charge 1 is 5 years that you're pleading to, and the maximum sentence for charge 2 that you're pleading to is 5 years, why shouldn't the sort of expectation of the defendant be that he's going to serve 2 sentences? As opposed to, in other words, are defendants so sophisticated that they just know if they commit a bunch of crimes at the same time, they get to serve them all together? Or do they show up and think, you know, I committed 2 crimes, I'm going to be punished twice? Even though, you know, again, as a sort of legal background norm, we have concurrent sentencing in Michigan. But I'm just thinking, isn't it rational for the defendant to be standing there thinking, I've just pled to 2 crimes and I'm going to face 2 penalties?
Well, I think that when you have an individual's liberty at stake, we should never force that individual to have to perform math. And the fact of the matter is that's what you're really saying to that criminal defendant. When you say you're facing a maximum of 5 years in prison, what they will hear is you are facing a maximum of 5 years in prison, and not probably doing the logistics in their head as to what that actually means if there's more than one offense.
I mean, but it's not said that way, right? It's said if you plead guilty to this offense, you'll face up to 5 years in prison on this offense. And if you plead guilty to this next offense, you'll face up to 5 years in prison on this next offense. So,
Well,
it's, you know, in other words, they're not told if you plead guilty today in court to all these crimes or some combination of them, this is the overall sentence you'll receive, right?
Well, of course, but we're not just talking about Mr. Warren's case, and we're not just talking about 2 OWI 3s. We're also talking about a variety of other crimes that can be stacked on top of each other. And in those cases, there's also no requirement at this time. If you look at the letter of the court rule, that would, you know, involve having to advise that person. And I would submit to the court that that's too complicated for any individual to have to understand who has not gone to law school and maybe who doesn't specialize in criminal law. And you are going to leave people susceptible to a set of circumstances that they are not truly pleading in a way that is voluntary and understanding, and certainly with an understanding of what the accuracy of their sentence. And it's just such an easy fix here. And I can really understand a circumstance that you have here with Mr. Warren, where, again, when he's told that 5 years, he's going to hear 5 years. And you could argue maybe he should have, maybe he could have performed those mental gymnastics in his head to add those together as to what that means. But I think when a court just very specifically indicates to a person exactly how much time they're facing, it creates transparency in the system. And there's less of a chance of a person later feeling as though they misunderstood what they were being told, and now they've somehow been deceived by the system.
Thank you.
Thank you, counsel.
Thank you very much.
Welcome to your first Supreme Court argument against your boss.
Thank you very much. David Porter, Assistant Attorney General, here on behalf of the people in Mecosta County. With me at council table is Deputy Solicitor General Eric Restuccia. So the question in this case is whether fundamental fairness requires a defendant be told that if you commit 2 crimes, you're going to serve 2 sentences. The answer to that is no, and I think we laid out in our brief sort of the legal analysis for how you get there, but I think it's important that we step back and remind ourselves why we're here, what we're talking about. If we were to go outside right now and stop the first 10 people on the street, non-lawyers, and that part's important, I'll get back to that in a minute, and we told them the facts of this case. Say a defendant goes out and commits crime A, punishable by 5 years, then he goes out again and commits another crime, punishable by 5 years, and we ask them, how much time is that person going to spend in prison? I think to a person, all 10 would say 10 years. 5 plus 5 is 10. And the same thing applies. We see this in pretty much everyday life. And so let me give you a quick example, and I think we'll illustrate the larger principle here. If you were to go home right now and go to your child and say, I'll give you a quarter for every chore that you do, and they go off and they do 2 chores, and they come back, and you give them 1 quarter, what you're going to have is a tantrum. because the child's innate sense of justice tells them that they're entitled to 2 quarters. And worse than that, they know that they shouldn't have to tell their parents that I'm entitled to 2 quarters. It's implicit in the bargain for 1 quarter for every chore. And it's the same thing with people pleading guilty to crimes. Now, I said I'd get back to the non-lawyer part, and I think that's important because we agree that if Mr. Warren was affirmatively misadvised about the applicability of consecutive sentencing, that would be unjust, that would be unfair, and it would require relief. But the solution there is not under the Due Process Clause. The solution there is under the Sixth Amendment, because really the only way someone would think that they are going to get concurrent sentences for 2 separate crimes is if they were told that by their attorney. And we agree that if that is the case, then relief is required. But the avenue is under Sixth Amendment ineffective assistance of counsel, because that's the case-by-case, fact-specific rubric that will yield just results, not in just this case, but in the next 100 cases, where yes, if somebody is misadvised, they're entitled to relief. But if not, it ensures important finality interest in all the other cases. So with that brief interlude, I'd be happy to open myself up to questions.
Counsel, first off, welcome to the court, and I think we're going to really enjoy having you. So welcome to the court, and it's really a pleasure to have you with us today, and we're looking forward to seeing you a lot more. But I just want to kind of go to the essence of it. I like to always kind of keep things simple. Help me to understand, why shouldn't it just be clear, unambiguous, and easy to understand that this is what the penalty is going to be? If you plead to this, this is what it's going to be. Where is the downfall? Where is the problem in making the law as clear and as understandable as you possibly can? What is the harm in that, and why is that not the right thing to do?
So I think you hit it right on the head right at the end there, where it's as you possibly can. And in this case, the possibly is not possible in this case because it's discretionary consecutive sentences. You don't know whether or not you're going to have your sentences stacked. And in fact, there's even a more important sort of...
So, but where is the onus? Why is this
that
so...
not possible?
Yeah, like, why is it so hard for the judge to be able to... Why is it so hard for someone to be informed that this is a possibility?
So that's a great question. And the argument on the other side is the trial judges are they're in the best position to provide this information. And I don't think that's the case. And what I would do is I point this court's attention to the ADM file that we referenced in our brief, 8148. And in it, you will see a letter from a group of experienced trial judges who responded to a proposal just like this requirement that we're considering here today. And they wrote to the court and they counseled the court, do not adopt this proposal. 1, because we do not have this information. And 2, not even the prosecutor will often have this information. We just don't know when the discretionary consecutive sentencing would apply. And so I think if this court feels that there is a sort of a gap here in the system, I think the best way to do it is through the rulemaking process, and I think you would get the same sort of feedback that this court heard in 1981.
We would have trial judges tell us, we can't really figure out the law on consecutive sentencing, so please don't ask us to?
Yes, and it's actually already reflected in this court's own court rules. I mean, there is actually a court rule that already talks about giving information about the applicability of discretionary consecutive sentencing. It's not from the trial judge to the defendant, it's actually from the probation department to the judge. It's the judge who's receiving this information about whether or not he has the power to do this. And it's done at a much later stage in the proceedings at sentencing after the probation department, through its, that has its channels, its databases, is able to find out what exactly this defendant has been up to in order to entitle him or open him up to consecutive sentencing. The trial judge doesn't have this information at this early stage. The one person who does have this information really to know whether this applies is the defendant himself. He knows what crimes he's committed, and it's through that conversation that you have with your trial counsel, confidential, it's a fiduciary relationship, it's through those conversations that you're supposed to have with your trial counsel.
So the admonition would amount to, depending on a bunch of different contingencies that we don't know about now, you might face consecutive sentencing in this case, right? That's what the trial judge is going to have to say.
Yes, and that was
Based on
actually...
a bunch of unknowns, it's possible, the probation department does their investigation. Let me ask you a hypothetical question. Under the due process theory, if it's a felony firearm charge and it's a mandatory consecutive sentence, is that a due process violation if the trial judge doesn't alert the defendant?
Yeah, so in the framework that we laid out in our brief, the direct versus collateral, and whether it's definite, immediate, and largely automatic, a lot of courts have held, yes, that's required under due process. Now, some courts in the federal system, despite that, say, no, you don't need to be told about mandatory consecutive sentencing. So I think there is a dispute, there is a sort of a disagreement there. We don't need to answer it in this case, because if you apply the framework that has been applied by most of the courts, the definite, immediate, and largely automatic, I think we fall on the collateral side of that, the things that the trial judge doesn't have to tell a defendant. So to answer your question, a lot of courts have applied the framework that we're endorsing here today to reach yes to that answer, to that question.
Do we have many statutes that are like the felony firearms statute, or are there more discretionary consecutive sentencing statutes? Or?
I think there are like 3 mandatory. There's if you commit a crime while you're in prison, and I think maybe while you're escape status, and then the felony firearm. But the felony firearm is sort of a unique statute, and it gives me an opportunity to discuss Blanton, because I think that was on this court's radar when they when you remanded this back down to the Court of Appeals. Really what Blanton is about, and what mandatory consecutive sentences for felony firearm, is really the mandatory minimum, right? It's a mandatory minimum that you have to serve, and that under the court rule, everyone agrees is required. So Blanton, in that sense, it makes a lot of sense, and it's totally consistent with what we're arguing here today. There's no disagreement between not requiring the trial judge to inform a defendant about discretionary consecutive sentences while still adhering to the Blanton rule, which is if it's a mandatory minimum of 2 years under the felony firearm statute, that's just required under the court rule.
Can I ask a meta question, just to hear your thoughts on it? So obviously, a criminal defendant gives up a lot when he pleads guilty. He gives up constitutional rights. He gives up the right to have a jury of his peer make a decision instead of a prosecutor. He makes any provides an efficiency for the system. But the public gives up a lot too in our sort of system of pleas that is no longer a system of trials, right? The founders thought that we needed a jury as a check on the government's power, right? The founders thought that was really important. If the founders dropped into our what's Frank Murphy today, they'd be like, what the heck is going on here, right? We all understand that. We the court, that's not for us to sort out. That's the way the system has evolved, and we've decided that we value efficiency over what the founders thought was more important. But the public is kind of giving up something in our current modern criminal justice system too, right? The ability to have the public be a check on the government. So does that matter at all? Does it matter that if we have given up something kind of important, the defendant is giving up a lot kind of important, does that make it just a little more important that the court be viewed as legitimate when it tells the defendant what he's facing?
Yes, and so I think you're right, but I think the portion of the colloquy that accomplishes that is the factual basis. I think we as a community all want to make sure that a defendant who's walking into court accepting responsibility is accepting responsibility for a crime that they've actually committed. And I think that's the important part of the colloquy. So
in this colloquy, what do you think made this fair? What do you think made this worth the bargain? Both the bargain the public is making in this new plea-based system and the bargain the defendant is making. What about what the judge said to the defendant made this fair?
He told the defendant, for each of these crimes, you are facing 5 years in prison. Now, the argument on the other side is, well, you needed to add those up for the defendant, but everybody already intuitively knows that if you commit 2 crimes, you're going to serve 2 penalties, just like you get 2 quarters for having done 2 chores. They're not misadvised. There was no misstatement of the law here. The trial judge did exactly what he was supposed to do under the court rules. And the reason for why discretionary consecutive sentences has never been required is because of this sort of fundamental principle, sort of universal to us all. It's how we approach these sort of economic or just real life situations. If you go into the fast food restaurant and you see on the board a cheeseburger for $2 and you eat 2 cheeseburgers, nobody is shocked by a bill for $4. You don't need to be told that that's what your total is going to be, so long as it's clear on the board that it's $2 for each cheeseburger. And it's the same thing with people pleading guilty. If they're told what their maximum for each penalty is, or each crime is going to be, they can do the math in their head, and everybody is already hardwired to know. It makes no sense for why you would serve only 1 sentence for 2 separate crimes. And I think the only way somebody would think that is if they had a sort of passing knowledge of Michigan law. And I think that's one of the arguments from the other side is we have a norm of concurrent sentencing here in Michigan. But the only way that matters, the only way that is related to this idea of fairness, whether it's unfair for a defendant to walk in and plead guilty.
But we don't decide things based on polling, 10 random citizens outside. So the fact that the norm is concurrent sentences, I think is relevant. So this idea, that's why I struggle a little bit with your 2 quarters sort of analogy, because there isn't this sort of underlying norm that, but for these sort of rare circumstances, in fact, they would be served concurrently, right? So somebody, I mean, we're not dealing with just, well, what do people feel is going to be fair, right? And your comment, I'm curious, you're saying part of the problem with requiring a judge to do this is that they don't know or can't know at the time that the possibility of consecutive sentencing. But doesn't that then suggest that requiring a defendant to plea and give up his constitutional rights can't be knowingly and fairly understood if even the judge has to be told by the probation department and all of this?
So I'll take those in 2 parts. The first is, if we're going to indulge the fiction that people know the law, we should indulge it 100%. And Justice Boyle made this same point in a dissental back in 1995, and we referenced it in our brief. She says everybody who commits two crimes should be presumed to be aware of 7B, which is the statute that's at issue here. And so if the norm really is consecutive sentencing in Michigan, then and we impute that knowledge to the defendant, then we should also impute the knowledge of 7B. That's the first part. The second part is, it's not unfair for a defendant to walk into court because he is the one person who has this information. He is the one who knows sort of the historical facts that would give rise to whether or not the statute applies. Now, the relationship between the judge and the defendant is sort of one at a distance, especially at the plea-taking stage. The judge is there to make sure that the plea is being accepted in conformance with the Constitution, but defense counsel is there for much, much more. It's for the defense counsel to counsel him on all these other consequences of pleading guilty that are ephemeral, indefinite, uncertain to happen. I can list off a bunch, but the point of it is that it's I don't think it's an indictment of the plea-taking process that the trial judge doesn't have this information, because the defendant will always have it, and it's the defendant's relationship with his defense counsel that should bring this to the defendant's radar. And that's why we think that this is better understood as an ineffective assistance of counsel claim. We don't know that in this case, whether or not he was misadvised by his attorney, but if it's true that he was, I don't see any bar to relief for him in, say, a collateral relief petition in this case.
So you see virtue in a process in which the defendant will mentally calculate 5 plus 5 or 3 plus 2, admittedly not extraordinarily complex calculations, but they will produce, as a result of that process, a number that will overwhelmingly, that in an overwhelming number of cases will be the wrong number.
Well, we don't know if it'll be the wrong number.
I mean, as you recognize, consecutive sentences are the exception, not the rule.
Yes.
So the addition that they perform mentally or otherwise will overwhelmingly be the wrong number for them to think about.
And that's why the effective assistance of counsel in connection with pleas is so important. That is why it's so important that defense counsel sits down and walks them through this and say, look, I know you've committed 3 crimes in succession, but believe me, they are going to be concurrent because none of these consecutive sentencing statutes apply.
So instead of relying upon the present court rule, or perhaps a more clarified court rule, we should instead rely not on the court rule, but on a constitutional provision. That seems to kind of turn the default principle that we tend to rely upon topsy-turvy. We try to resolve things on the basis of non-constitutional calculations when we can do so. But you would focus on that as the all-purpose remedy as opposed to trying to accomplish or affect that same remedy by the court rule or, again, an improved court rule.
So the court rule in this case is animated or directed towards making sure that the Constitution is complied with. And for decades, the two core components has always been, the nature of the offense and your statutory maximum. But that is just one leg of the stool to make sure that the plea is constitutionally valid. Another important leg that I think everyone is forgetting here is the effective assistance of counsel. Going back to Brady versus United States, and even before that, the Supreme Court has made clear that a vital component of a valid plea is the effective assistance of counsel. And so while there may be virtue in a concise prophylactic court rule, I don't think that's possible here if it's going to have the benefit of making sure that those defendants who are facing consecutive sentences know it, and those who are not aren't told that, because that can be just as confusing if it's a court rule that requires them to say it in every single case. That can be just as confusing for all the defendants who are not subject to consecutive sentencing as those who are and are not told. That's why the case-by-case approach is the best through the ineffective assistance of counsel. I see I'm running out of time, so we'd ask this court to deny leave. Thank you.
Thank you very much. The case will be submitted. You tried, but it didn't work out.